Good morning. I'm Mario Joyner, Vice President and Small Business Sales Administrator for Nevada State Bank. I'd like to welcome you to today's webinar titled Insights, How to Reduce the Risk of Litigation. The webinar is presented by Nevada State Bank through nevadasmallbusiness.com. We're excited to have two attorneys with us today from the law firm of Snell and Wilmer, John Delikanakis and Ray Jones. Mr. Delikanakis is a partner in Snell and Wilmer's commercial litigation group. His experience ranges from counseling senior management on operational issues to litigating both simple and complex cases at the district court and appellate levels. Mr. Jones is a transactional attorney who advises clients on a wide range of corporate matters, including business acquisitions and mergers, corporate governance, owner relations, business structuring, and formation. If you have questions for our panelists, please submit them via Twitter using the hashtag NSBWebinar. Without further delay, I'll turn it over to our panel. Good morning, gentlemen.
Good morning.
Morning, Mario.
I guess the best way to start is just to talk about some of the basic principles that you guys both will cover today as a result of the webinar.
Yeah, there's some kind of overarching common sense advice that Ray and I sketched out from our experience as to kind of basic principles, and I don't think these basic principles are very surprising to anyone. You know, there's the old saying that everything I ever needed to learn, I learned in kindergarten, and I don't think these principles are too far afield, but go ahead, Ray.
No, I think a lot of it will be common sense type things that we bring up, but things good to know if you're a small business owner, how you can structure your business in a way that will, if you can't prevent litigation, because in reality, if somebody wants to sue you, they can, but put you in a position to where you can defend yourself effectively, efficiently for a lower cost. But that's by doing some of your legwork up front, and we'll talk about some of those things, why people litigate, and how to avoid it.
Yeah, but basically some of these principles are, they're common sense. Read everything, and not only just read everything, but understand everything. And the first test comes when you read something and you don't understand it, and you might be uncertain as to what the effect of what you're reading might be on your future business. What do you do?
What do you do? And if you don't know the answer, then it's, in our opinion, good to consult somebody who is an expert in that area. I used to give how to start a small business seminar. I'm a member of the Latin Chamber of Commerce, and I used to do this on a monthly basis for people who were starting small businesses. And I'd talk about the legal issues that they would face. Part of that was which type of entity should you choose, and consulting with a lawyer. I always said you should have a good lawyer, you should have a good accountant, you should have a good insurance agent. Those three things are really important to start a small business, because those are three individuals, professionals that you're going to rely on an awful lot.
And they provide guideposts. Look, lawyers, I always joke, are notoriously bad business people because we're trained to be very fact-oriented, very cautious. Our whole livelihood depends on being able to look at the future and kind of predict.
And evaluating risk.
Yeah, evaluating risk, look at the chamber of horribles. Whereas, our clients are entrepreneurial. They're innovative, they're creative, they think, I hate that phrase, they think outside the box. So they're exuberant and they want to go do things right away. Use these three professions, accounting, lawyering, and insurance, to at least give you some guideposts at the earliest stages of your business, because I think you'll find life much easier in the future. So that's pretty much kind of, I think, the basic principle. But some other principles are, you want to do business with people you trust, right? If you're meeting the smell test and you're getting an uneasy feeling in your stomach, you probably need to think twice about what you're doing.
And it's very easy to get excited about a new venture and about a new business. And with that excitement, you may skip some steps of due diligence. You need to know who your partners are, and you need to select good partners. And it takes time and effort to really compile the information that you need to make that good business decision.
Yeah, and sometimes these decisions, what we've seen in transactions in the past, you've got someone who's the idea. He's the idea person, or she's the idea person, and they've got this fantastic idea, and then they go around looking for investors. And the investors are eventually going to be the partners. And sometimes the overriding concern is, I need money, I need it now, I really don't want to look too deeply as to who I'm doing business with. That's a huge mistake, I think.
Yeah.
Because that's where the problems often come, where people that invest may end up wanting to control your company, may end up wanting to push the founder out. So
they may be very litigious, and it's pretty easy. You can do some due diligence up front, find out about this potential partner. Do they litigate? Have they been in 10 partnerships and they've litigated every one? You'd like to know that before you sign any documents with that person, because chances are you're going to end up just like those other partners have. So doing that type of due diligence up front is very, very critical.
And it's all publicly available. I mean, when the lawsuit is filed, it's a matter of public record. So you can always find out if people have been involved in litigation. That's a fairly easy step. But the second facet is, once you do find these people, you need to document everything, right? And we've seen this with the initiation of business ventures with friends and family.
Yeah, it always starts out great. When it ends, it usually ends because it will end poorly. Absolutely. Otherwise, it wouldn't end. And so documenting everything, using business entities to limit your liability as a principal of the company, and also to, to govern how somebody leaves a partnership or leaves the company. Exit strategies, or how you bring new people in, new money, new partners. All of that can be documented up front. And this is one thing that I advise clients often. As a small business owner, usually you're undercapitalized, usually. Money is always an issue. And so it's going to be an investment up front to do these things. But it's our opinion that those will pay off in the long run. You get hit with a lawsuit, any lawsuit, even a small lawsuit, can be hundreds of thousands of dollars. Yeah. And that could wipe out a small business. So doing this type of due diligence, this type of documentation up front can save you from that.
What I've noticed in just some shared experiences is that these are typically issues that have lingered for a while. So they let them fester, and then they become matters that can become litigious. So resolving them early sounds like something you want to do. Right.
Addressing them early. And that's kind of an underlying principle. As a business person, you're occupied with running your business. If you get a sense that there is a trouble brewing with a client, or with an employee, or with a vendor, the best thing to do is to address it sooner rather than later, because quite often as a litigator I've seen when a lawsuit gets filed, whether I'm the one filing the lawsuit or if I'm the one defending the lawsuit, before a lawsuit's filed, I always ask clients, have you guys talked about this? I hate them. I don't want to talk to them. Now, you really probably need to talk to them, because it'll be cheaper if you talk to them rather than having me and their attorney talk. So a lot of times, especially in closely held businesses, there is a history that has built up over time, and there's a level of rancor and distrust. So I always advise people, try to talk to people before you file a lawsuit. And even after you've been served with a lawsuit, I ask my client the same thing. When's the last time you had a conversation with the principal, meaning the owner on the other side? That's always like one of the first questions. And what did you talk about? And where did the conversation leave off? And where did it end, right? I mean,
as attorneys, when we're representing clients, it's very easy to build our case and represent their best interests. And you can at times come to a loggerheads with the other counsel. And so principals, if they are open and amenable to that communication, having open communication, even though they might not like each other, it can save money for them to at least take that initiative to communicate before they get professionals involved.
Well, it's a great segue to what I was going to say, which is, once you've tried to reach out to the other party and you haven't had success, it seems pretty important to get someone like yourselves involved. Look at a professional like yourself to try to mediate between the parties.
Yeah, I mean, that's every case is different, but quite often, particularly with parties that have been through the litigation dance before, and know what they're facing, quite often an early mediation is a good first step. But I was kind of hoping to cover, why do we want to avoid litigation?
Right.
I mean, there's some, the reasons we want to avoid litigation are obvious, but I think they're worth restating, right, Ray? I mean. Absolutely.
As I stated earlier, if you're involved in litigation, it will cost a lot of money. There's no doubt about that. John, as specialized as he is, he's expensive, and and litigation takes a lot of time. It can be years in the court system, and so, as a business owner, you don't want to tie up your resources in litigation and your time. It can be a huge time commitment as well. So money is really the underlying factor of why you'd want to avoid litigation.
Yeah, trust me. You get clients come in sometimes, and often justifiably, they're really upset. And I get it's the principle of the matter. And you can hear them kind of chuckling. By the time of the third month of bills or fourth month of aggressive litigation bills, it's time for a reassessment of the principle. But that's a conversation you want to have early on. But it really is just money. In other words, the money that you would spend to set up a company, or at least set up guidelines or procedures or a structure that's been well thought out, is money well spent. I can't emphasize that enough. I mean, because I assure you, a heavy piece of litigation that really gets busy will run you tens of thousands of dollars a month. Wow. And when you understand that many cases have a lifespan of 3, sometimes to 5 years, where you might have 1.5 to 2 years of active discovery, which means the process of gathering information from each other, you start drifting into the area of 6 to 7 figures, if not more. I've talked to other commercial litigators, and we've come. What's happening outside of tort litigation is that true commercial litigation, which is a dispute between two businesses over breach of contract, is becoming more and more the realm of larger businesses, because the sums often at risk for medium to small businesses just don't warrant litigation, right?
Yeah, if you have a claim for $50,000, if you think you've been shorted $50,000, oftentimes it's not worth it to litigate. And so the point I would make is, anytime you get sued as a business owner, it doesn't mean you're going to end up in one of these large litigations. The way you set up your business, the way you set up your entity, can actually save you from getting drawn into one of those, large, protracted litigations. And so, having that type of protection up front can help you there.
Right, and the other phrase we use is risk avoidance, right? Businesses don't like risk.
Right.
And there are many ways that Ray, when he drafts documents for a company or forms a company can be formed to avoid risk going future, or try and deflect risk, not only in the formation documents, but even in contracts when you deal with independent contractors, with vendors. I mean, there are many ways. Every time you enter into one of these contracts, you should meet with a transactional attorney that can help you deflect, put indemnification provisions, push off certain activities that might be high risk that you don't want to be directly responsible for, you can contract for. So there's risk avoidance. But the other thing is also uncertainty. So you've got risk avoidance and uncertainty, because there's never certainty in litigation, right?
That's
never.
Never.
I don't care how good your case is. At the end of the day, you're still in front of a jury,
right,
or in front of a judge if it's a bench trial, and there's no guarantees. So to the extent you can identify, address, and confront and deal with issues, either before they occur through good drafting, or immediately after they occur and consult with a good litigator, you should do that.
Yeah, and it should be noted, it is a huge distraction for a company to be involved in litigation. And as a business owner, you want to make money. Your business is to provide goods or services to the public, and that's what your focus should be on. And so, avoiding litigation obviously will prevent you from being distracted in doing what you do best.
Yeah. There's also damage to business relationships. I think you've probably seen that in transactions or transactions going forward with somebody that you once litigated with, or damage to reputation and business relationships within a certain industry, right?
Yeah, it's hard to recover from something like that. In fact, I have a developer in town where they won't contract with a particular lender because, and this is a large lender in the United States, because of something that lender did to another developer in a totally different market.
Wow.
That led to litigation, right?
Yeah,
it was public,
absolutely.
So it was public.
It was public, but because they know about that relationship, they just simply will not contract with them because it's too risky because of what had happened.
Yeah, that's probably, once you enter the realm of litigation, a lot of secrets come out.
Right.
A lot of secrets, and if someone really wants to look into a piece of litigation, what occurred in the transaction that's disputed, the conduct of the principals, the conduct of the employees, all is a matter of public record because it's all kind of often introduced in motion practice or in trial, right?
Or in depositions.
Or in depositions, which often are used and then used in the public realm, right, where people talk. So there's a public relations aspect to why you want to avoid litigation. Often, if you are known as a litigious company, just like when you find a business partner, right, you don't want a business partner that's sued the last 5 partnerships they invested in. So same with a company. You want to do business with a company that's always arguing over a contract after they've entered into it? No.
These are all great reasons, obviously. So why does litigation happen? With all these great reasons that you just named, it seems like it makes a lot of logical and financial sense to do so. Why does it happen?
Due diligence, right?
Well, I think I'll preface that with sometimes people just lose their minds, and that's the sort of the wild card that it's hard to plan against. I mean, you can, like I said, you can prepare yourself to put yourself in a good position in case that happens. But there are some instances where people will just litigate because we live in a litigious society. It's part of doing business, unfortunately.
Yeah. Other times we've kind of touched on it. It's stubbornness, it's pride, it's principle, and it's emotional. And that's why, one of the things that a lawyer does, both in the transactional realm and in the litigation realm, is to be dispassionate and objective, right?
Yeah.
So when you're forming these companies, let's say a closely held company with friends and relations, what's your role, Ray?
My role is to form the company in such a way that when things aren't great, then they can have an ordered exit. And for small businesses, I like to use an LLC, limited liability company, because it provides limited liability to the principals. And with that, you can create what's called an operating agreement, and that's really the agreement that governs the LLC. And in that, you can basically form it and set it up the way you want as principals. You're called members to an LLC, and that document is very important. It's key to governing how somebody comes in, how somebody leaves. If you just have a general partnership, you have no documents like that. And so when it does go poorly and somebody wants to leave, that's where you have more risk of litigation. So again, starting with an entity that provides limited liability and has the documentation that can govern that relationship.
That's one area I see just in my own personal experiences, that there aren't enough operating agreements. We require them doing certain aspects on certain transactions, and a lot of the business owners don't have one in place. So I try to then encourage them to look at getting this document in place, not for this transaction, but just to help govern your business. And
that's good advice, because it's one thing just to have an operating agreement, but I can't tell you how many times you want to have a well-drafted operating agreement that addresses the particular needs of the investors and the principals, because every transaction's different. And depends who the players are. I mean, are they family members, right?
Yeah, it depends on the type of business that they're doing.
Right.
There are tax implications to all of this, and so having that accountant, having a good tax attorney to assist in the drafting of that operating agreement is critical. It really is.
Absolutely, and will save you a lot of time. And it also forces business owners to make some really hard decisions quite often early on as to, who's going to do what will be the role of members, what will be the role of the operating member or the managing member, as we call them. And these are things that really need to be at least considered at the beginning. It may evolve over time, right? You may amend your operating agreement, but it forces a business owner to kind of really think hard about who's going to do what, who gets what interest, how are we going to calculate the value of that interest on the way out, right? You often put formulas into these on exit trades. So there's no question, like one guy says, I'm having a divorce, I need to cash out, I need to get out. Well, if the operating agreement has no way to address that, I can tell you that's going to be a problem.
Yes.
Because that business will get drawn into that divorce litigation if there is.
Yeah, or the member is going to be unhappy with how the entity calculated the value of his membership interest. That's where I've seen litigation.
Right.
Yeah, really, like, what do you mean? This is all it's worth? But if you have that discussion between the investors and the owners early on, and you say, this is how we're going to do it, there's no dispute. Well, there shouldn't be. Or if there is, you have a well-drafted document that everyone signed off on and say, that person is just being unreasonable because they already agreed to this.
Right.
This is how it works.
And
That's the power of a good.
And then when if you do end up in litigation, then you stand a much better chance to be able to either have it dismissed or to defend your position much more effectively. You have a document. This is what it says. It's very clear as to what it says, and that will govern, how hopefully the judge or the court rules, and hopefully in your favor because of what the document says. So starting with clean, well-drafted documents that not only address tax implications, but current Nevada law. How many times we've met with businesses where they have documents that are 20 years old, and it was a form that they got maybe off the internet or in Arizona, or their brother's an attorney in Washington, and so he gave it to them, something like that does not have recent, accurate Nevada law in it.
That's a good point.
That's a big issue. And so that's what John said, a well-drafted operating agreement, not just an operating agreement, but one that's accurate and well-drafted is also very key.
Yeah, your point of, a lot of people don't realize that although we're one great nation, we are a great nation with 50 separate bodies of law
and jurisdiction.
And jurisdictions, and we'll talk about that later, but it is very important when drafting these contracts, or even when you start engaging in contracts, again, with independent contractors and vendors and people you do business with, that you at least have someone take a look at it to make sure the clauses in there are actually enforceable under Nevada law or this jurisdiction's law, because some clauses are not enforceable for various reasons, but that's something you would consult with a lawyer with. But stubbornness and pride, so if you have this kind of self-evaluation at the very beginning of the relationship, it kind of it humbles you when 5 years later and you actually do get into a fight, you look at the documents like, oh yeah, we already discussed that. Okay, so pride and anger kind of gets diffused because you looked at all this before.
And so other than the pride, stubbornness, give me some other common reasons that litigation happens.
Well, one thing that we saw, with the recession, 2007, that was an event or condition of the market that nobody could really foresee. Nobody foresaw it. And so, litigation was a result of many business relationships there where that was just something that was unexpected. Again, planning, you can't really plan for something like that. You may end up in litigation, but again, putting yourself in a better position through prior due diligence, through prior planning, will at least help mitigate some of those issues.
Yeah, and we touched, there is a failure to communicate. This is the old cool hand Luke. We have here is a failure to communicate. I can't tell you how often litigation was preceded by failure to communicate, so I want to really stress that. And the other thing is just out and out greed. Unfortunately, litigation is often driven by greed, whether it is people file lawsuits sometimes for the wrong reasons, but you can't stop it, but it happens. Some litigation is filed because, believe it or not, in some situations, particularly in larger transactions, it may actually make economic sense to breach your contract. and then suffer or go through the trials of litigation. For example, if the amount at issue is $24 million and the market's gone upside down on you, and you've got this huge debt on a piece of land that isn't worth $4 million, it might be actually worth it to you if you are a wealthy individual or a wealthy company to breach that contract that you have with, say, a lender. Say, you know what? There's no way this land's ever going to be anything that I paid so much money for, so I'm just going to breach my contract and you can come after me. And I might spend $1 million or $2 million fighting it, but it's cheaper than continuing to pay the $24 million. And, you know, I think in law school they taught us it was called an efficient breach, right?
Right.
I just call it a breach of contract, and people should honor the contracts, and, you know, that's how you should lead your life, right? But sometimes business entities will make that very calculated decision. Not often, but I've seen it.
Mm-hmm.
Yeah, I have seen it.
And just one other point I wanted to make with regard to communication. You know, the governor has been trying very hard to expand and diversify our economy here in Nevada, and we've been encouraging businesses to export, to seek you know, business relationships outside of the state, outside of the country. And one thing that's is important for a business owner to understand is, you know, how you communicate here in your home market may be very different from how somebody else communicates. And so understanding those cultural differences between markets is critical. Having somebody who's been in that market. And, you know, languages might be different, but just the way people do business could be very different. And so having somebody who has experience dealing with that other market jurisdiction will be helpful to a business owner.
Absolutely. And, you know, the fact is that, you know, we talk about globalism. We are truly a global marketplace now. I mean, in Nevada, we've got businesses that are doing business all over the world. We trade, sell goods, not only just to other states, but to other countries. And often the transaction will be a cross-border transaction. So whenever you do one of those, Rays, you have to look you have to look at the cultural differences and the bodies of law, and, you know, how do you address it? I got a case with that originates with a country, another country, and I'm dealing with foreign nationals, and, you know, there's communication issues, there's explanation of how our legal process works. But as a business owner, just as we have to deal with that, as a business owner, there's that hurdle to get over. So each party's expectations are managed, or at least understood. Yeah. Because quite often there is a misunderstanding. They just go forward with the transaction, and no one talked about certain issues.
Or when they're talking past each other.
Right.
They think they're talking about the same thing, but in reality, they have something else in their mind that they think they mean. It's very easy for people to talk past each other, which is why it's important to document it correctly, but to have an understanding as what the document means. Now, I've done study in this area about cultural differences with regard to contracts, and the experts, or the academics, they call it universalism versus particularism. Universalism is a focus on the rules, which is in the United States, four corners of the contract. This is what we believe governs. In a society or in a jurisdiction that is more particularist, that's where relationships really govern. And what they do in those areas is they enter into a contract, and then the relationship governs how they're going to interpret that contract. And it may evolve over time. So if you have these two different ways of looking at a contract, one person that says four corners, that's it, and then you have somebody else who views it the other way, that can be very difficult to overcome. And so understanding those differences, and then not only understanding them, but learning how to overcome them is critical.
Right. So to the extent when you are shopping for a lawyer, so to speak, for a particular transaction, if that is out of the ordinary, say dealing with a Chinese company or a Canadian company or a Mexican company or a Thai company, to the extent you can find lawyers that have actually papered those transactions or have some insight into dealing with people from these other countries or what their expectations are to a transaction, you'd be well advised to do that as a business owner. I really think you should. And there are a lot of people out here. Nevada continues to expand globally, and because of that, there are any number of lawyers like Ray and other law firms as well that can assist you with these types of transactions. So at least you manage the expectations, your own expectations, and hopefully also educate the expectations of the foreign national that you might be doing business with.
Yeah.
So it'll avoid a lot of problems later, trust me.
Yeah, I had some experience with some companies that had a great product that they could offer, and whether it was locally or nationally, and they expanded their reach internationally, and they had some success and helped them weather the storm when we had the Great Recession. So your point's very valid, that there's a lot of conversation and point of reference to expand your market outside of our 50 states. That's a real conversation being had by a lot of business owners. So,
absolutely, absolutely. I serve on the Nevada District Export Council, and that's our whole purpose of being is to encourage companies to export internationally, and that's one of the main benefits is that when you have a lull or a dip in domestic production, you can rely on those international markets to pull you through those tough times.
Exactly. There's the, I guess we want to talk a little more about how to avoid litigation.
Yes.
We've kind of talked about that, but what are some other tips? I guess updating, we've talked about proper entity selection, right?
Yeah, again, my personal view for a small business, an LLC is ideal. It provides limited liability. The tax structure is pretty easy. Pass-through taxation means it goes through the LLC to the individual. So as a member, you just have to worry about your own taxes. The corporate governance is pretty easy. It's basically, you don't even have to have meetings like as you would in a corporation. You have one-page document a year that you have to file with the state to maintain your registration with the Secretary of State. But it's really easy, it's user-friendly, and it provides that protection to the principals.
And we're fortunate enough to be in a state where there's a lot of interest in doing business here, or at least having some formation in Nevada, so that's a great thing.
Yeah, we pride ourselves as the Delaware of the West. And we do have a good corporate business climate, and we do have an ever-increasing amount of people, particularly from overseas, not just China, but Korea, Thailand, Canada, and Mexico in particular, that are very anxious to do business here, whether it's manufacturing or using it for logistics, transportation of goods. I sit on the board of directors of the Las Vegas Global Economic Alliance, which was the old Nevada Development Authority, and I can tell you that is definitely an area that we're focusing on and have had some success in. So all these other cultural issues, I think, are going to continue. Again, we're a global marketplace. I mean, we've got people that openly sit here and talk, well, I live here in Nevada, but I'm opening up a business in the free trade zone in Dubai because it makes economic sense, and I'm also importing goods from Mexico. So physical location these days is not the only thing that's going to govern your business. So you have to be open to how you paper these transactions going forward.
Yeah, and just segueing off of that, entering into a contract, there are times when two parties will have what's called a term sheet, letter of intent, or an outline of key terms, that sort of thing. And basically it's supposed to sort of frame what their transaction is going to look like until they can enter into a binding agreement. There are times, unfortunately, where the parties don't have specific language necessary in those preliminary documents to prevent it from being an agreement. And so I just actually brought one. I wanted to read some of the language that I thought was effective to preventing the term sheet from being enforceable as an agreement. And this is just between a couple of parties that I'm representing. And it states that each party acknowledges that a transaction of the type contemplated by this letter involves additional material terms and conditions not set forth in the term sheet, including without limitation, satisfactory completion of due diligence and financing commitments, and agree that both parties, neither of both parties will be legally bound unless and until the parties execute definitive venture documents for the venture, except as may be set forth in a definitive agreement executed by both parties. Nothing herein is intended to create a joint venture, partnership, or informal association or relationship between the parties. It has to be that specific to state, these are what we would like to enter into, these terms, but we're not entering into an agreement right now. You have to state that specifically. If you don't have this language, then your term sheet could be an enforceable contract.
The term sheet, the back of the envelope, the cocktail napkin can all end up being a contract.
Right.
Because what you often see is people say, well, we sketched this out on the back of the envelope, and then he did this, and I did that, and I relied on what he was doing, and I continued to do it. And before you know it, you've created a contract that no one ever...
You've gone down a road.
You've gone down the path.
And if one of the parties wants to then leave, the other party could say, well,
Wait.
hold on a second, I'm relying on what we've done here,
Right,
what we've
right.
written down, and you don't have this language to rely on if, the party who wants to leave.
Yeah, and so that's why, again, it's almost counterintuitive. You got business people, they're excited on a project, they're in the meeting, they're in the bar, they're sketching out things they want to do together. I can tell you, no one ever thinks, hey, we should call a lawyer. I mean, that's the last thing you want to do, right? As a business person. Let's call a lawyer. But you know what? My advice is, you need to call a lawyer to save yourself a lot of trouble later on the LOIs.
It may, there's a form substance question there. You have to have the right form. It has to contain the keywords in order to protect you. It just has to be there.
It's not an expensive endeavor. I mean, really. I mean, to consult with an attorney to help you along with your LOI, or just at least make a couple phone calls like, what should I do, as we're plotting out what we want to do, is not an expensive proposition.
Well, it should be a part of your startup costs. It should be a line item that's a part of it. Marketing, advertising. This is you should have a line item there. I agree.
And here's another kind of related thing you see. I've seen. I'll get a group of people come to me and say, "Hi, we're forming a company. We'd like you to represent us." Right. And I look at them and I go, "All of you?" Am I representing? Who am I representing? Am I representing the company, or am I representing you because you brought all your buddies here to form this company?
Right.
And I tell business owners this, and it's all well-meaning. It's at the honeymoon stage of any transaction. Is that as you go forward, you need to consult independently with your own attorney if you are going to make an investment in a company. Don't rely on your buddy's attorney who is a co-investor. Just don't do that.
And one of the key issues there is if you're representing the company, you can't withhold information from any of the principals.
So the attorney-client privilege is out the window.
Right.
Yeah, and I think what happened is often an attorney will ask the right questions. Will say, now you do understand that if I represent the company, I can't represent any of you.
Individually.
Just so you understand that. And that really, and then I think their faces kind of fall like, well, what do you mean? We got to hire more attorneys? Yes, you have to probably hire more attorneys. And that's not a conversation anyone wants to hear, but trust me, it's best that each of you have independent counsel to paper this deal.
Can the counsel be within the same firm, or should they seek representation from...
Independent counsel means
Independent, separate
counsel.
counsel firm, because conflicts in Nevada and as in most jurisdictions are imputed to every member of the law firm.
Got it.
Right. And it's not something you want to get waivers for. Really, that's just a bad idea.
And that's every member of the law firm. So,
all
our
5 offices.
Oh, wow.
Oh, yeah.
So not just even the immediate physical location, it
No.
expands.
We have 9 offices in 5 different states, so it's imputed to everyone.
Right. Definitely. Most definitely. Maybe we can talk about just kind of updating of forms, the importance, it's not only forms, contracts, handbooks.
Yeah, we'll do that from time to time.
Yeah.
We'll have, some of the largest companies in Nevada will come to us and say, hey, we have in-house counsel, and these are large companies that have, large in-house legal departments, but they'll say, hey, we want our forms updated. And we did this with one of the large companies on the Strip where we went through basically everything that they had. It was a couple of month process, working with 15 attorneys from 4 different offices in our firm to go through all of the agreements, look at the law, see if it's changed. And again, this might be more appropriate for a larger company, but you can do it on a smaller scale with a smaller company. But do that every couple of years with your form agreements. If you have lots of vendors, if you're entering into those types of contracts often, you do that type of maintenance, I would call it, on your forms, and that will also help to avoid, because the law changes, and it'll help you avoid litigation that's totally unexpected.
Especially in the realm of employment.
Yeah, I was just going to ask that.
Yeah. What was your question? Go ahead.
No, you just hit it. I was going to say, would that include even some of your employment contracts?
Oh my gosh, yeah. And your
Absolutely.
handbooks, because in Nevada, as in a lot of other states, the employee handbook can be a contract between you and the employee. So it is important that you review that employee handbook periodically to make sure it comports with the federal laws that are always changing in the employment area, but also in Nevada as well. And that also goes with other internal policies and procedures. In other words, companies, even mid-sized companies, probably have a very informal policy, but they might have an informal policy on how long do I keep records, or how long do I keep my tax records, or how long do I keep employee records. So you can probably avoid some problems if you have a good document retention, destruction policy in place. Again, we're consulting with an attorney for various statutes of limitations, what's requirements of the laws to maintain the records. Save yourself a lot of hassle. Other just common sense tips, having seen this, and certainly applicable to small to medium-sized businesses, is just having a good sense of where things are. Where are the documents?
Physically knowing where they are.
Physically, like where are your documents? Where are your emails? Where do you keep your contracts? How do you maintain them?
Having a proper document retention policy.
Yeah.
Because again, ending up in litigation, then not having the documents that you need to defend yourself is just as bad as not having those documents in the first place. So,
how frequently to keep this policy procedure updated? Is there rule of thumb, or?
Well, the rule in Nevada as to lawyers, we have to maintain our files for 7 years.
7 years.
Yeah.
Other jurisdictions it's 5 years, or 5 or 6 years. But I would at least have them for 5 years, even after, if an employee leaves, at least after the statute of limitations runs. But it's hard to follow those for every employee that you have. But I would say at least 5 years.
Yeah, and that's where even in a smaller company, you want to have some sense of how long do I need to keep Marge's file after Marge quits or Marge is fired, right? Because especially, it's all on a case-by-case basis. If the termination was acrimonious and fought, you're probably going to get an EEOC charge. So you might as well go ahead and do this. And this is kind of a purely litigation thing. There is a duty to preserve things in Nevada, in a business, when one reasonably knows that litigation or a claim might be made. Okay, so let me give you an example. You're a small to medium-sized business.
Right, there's no Enron shredding of
There's
the
no,
document.
you can't, no shredding, none of that, no deleting, because
Right.
everything gets deleted anyway perfectly. You don't do that. So if you sense that you are entering into a dispute or a vendor has sent you a letter, you need to pay me, you have not paid me, you have breached the contract. Well, that's notice of a claim, right? Mm-hmm. So any business then needs to go through the process of retaining and maintaining documents related to that dispute. Word from Lawrence, destroying it will not help you.
Not at all.
No. It will not help you because what do courts do? They give you an adverse inference or they do horrible things to you if you destroy evidence knowingly. On the other hand, if you have some sort of document retention policy, you get notice of the claim, everything comes to a grinding halt. But if you had a policy that says, I destroy things after so many years, it's not going to be held against you that you didn't save
Right.
the entire history of your relationship with this particular vendor or business because you had a reasonable document retention policy that allowed you to destroy things.
So some businesses, for example, emails, company emails, they'll have a policy where they'll hold on to those for 2 years or 3 years, and then they'll purge them from their system. That's completely reasonable to rely on that. And if there's some information that is gone because
gone.
of that policy, it's gone.
It's gone.
And it's okay.
On the other hand, when you get notice of a claim or an EEOC charge or even an email quite often from an employee, I think you've been unfair and I'm going to pursue my rights. Well, that's notice. So at that point, any size business should really just take a step back and then just start to find out where is information related to this claim, meaning preserve emails, preserve memos, talk to your IT department, and if it's a really small company, just start rummaging through files and segregate everything you can about this. It will save you a lot of trouble later and a lot of cost. Just do it. Because unfortunately, I've seen people who don't understand, there's no reason they should understand the legal process. They've never been sued. And they think, I'm just going to delete this. It'll go away. They'll never find it.
Great best practices. Any others you think we should mention?
We were talking about updating your forms or updating your contracts. One other thing that we often do with clients is, and again, this may be with larger clients, but as a company is growing, doing these types of things on a smaller scale would be helpful. But some of our larger clients will actually bring us in. And for example, a few months ago, myself and 2 other attorneys, we went and we visited one of our clients. They flew us up there, we were there for the day, and we were able to talk about several different subjects that was applicable. We addressed their employees directly, talked about best practices, and just sort of went through some scenarios so that they could get training on how to avoid these types of issues. That type of training is invaluable for a company and for the employees because, like John said, somebody's never personally been sued before. They don't know how to act exactly, and so talking about those best practices will help them and will help avoid litigation in the future.
Absolutely, especially in the realm of the employment area. That's where lawyers can bring some value to any size company by even having it come in and do an afternoon quick meeting.
Swen Pryor, who's our employment partner, he does that often. He'll just come in for a couple hours and talk about those types of issues.
Right, and I've done it with document retention and e-discovery issues, which is kind of my baby that I like to talk about a lot. I'll go and meet with companies and sit down with their lawyers and we'll talk about what policies do you need so that you don't get sideways with the discovery process later. But in the, go back to it in the employment area, even in a small company, to have that kind of reality check from an outside person as a lawyer to say, you know what, showing those dirty pictures to your hot secretary, not a good idea.
Not a good idea.
And you see it often in very small companies because it's a feeling like we're all just kind of friends and I'm the owner and I can do whatever I want. Sometimes you need an outside lawyer just to kind of do that. This is what's actionable, meaning you can get sued. This type of conduct is actionable. It will cost you a lot of money. It will be embarrassing. So, well worth it. That's why it's well worth it. So have a handbook if you can have one. If you're too small for a handbook, maybe just get some basic guidelines and some trainings for your employees as you grow.
And I don't think anyone's too small to have an employee handbook. If you have an employee, you should have an employee handbook. I sit on the board of a charter school in town. There's 2 administration and 6 of us on the board. They have an employee handbook for the 2 administration, just because we're going to grow at some point, and you have to have those policies in place to govern those relationships. It just makes sense.
Absolutely.
Well, let's transition. We have some questions that were sent in by people who registered for the webinar, and I'll just throw these questions out.
Go ahead.
Either one of you guys can feel free to answer. First question, if an employee threatens to sue me and I settle out of court, won't they just encourage other employees to do the same thing?
Go ahead.
Well, there's some key things that you can do as an employer. And one, you have to evaluate the claim. If it's a completely frivolous claim, then you may not want to settle. You might want to fight it to prevent this type of thing from going on. But if you do decide that it's in your best interest to settle, then obviously your settlement agreement will have some sort of confidentiality provision in it, obviously. You would want that both sides can't disparage the other.
Right.
And then as an employer, you may also include in that settlement agreement some sort of liquidated damages provision. So if the employee breaches the confidentiality, then they would be on the hook to pay a certain amount back to the employer. And so
Yeah.
you can make it difficult for the employee to breach that confidentiality.
And as a business owner, is there any insurance you think I should have to protect me against such an act?
An act of being sued, or?
Well, if I am sued, to make certain it does.
Well, there's
D&O.
D&O, director and officer insurance.
Okay.
I mean, and that's why, again, going back to what Ray said at the very beginning, it's very important that you do consult with a good insurance agent to figure out what kind of insurance do I need. It may, it's not just
And what
premium.
levels of insurance, depending
Right.
on what you're doing.
And the size of your business, and is there a way to shift risk to subsidiary entities if you start to grow a little further, or is it better to just have somebody else do it? But it's funny, I was having a discussion about non-disparagement clauses, and I think I finally come to the conclusion, particularly where it's really acrimonious and they really hate each other. To me, that's just an invitation for litigation. I had this discussion with Pat Rifo out of Phoenix as well.
Oh,
Yeah,
really?
we just came to that same conclusion, just like, because what's disparagement? Boy, when you have ambiguity, you have litigation. So if they really hate each other, say, well, I heard that she said, and that's why you breached the contract, the non-disparage. So use it, but use it in some cases you probably don't want to use it.
And to get around that, in your settlement with your employee, you can actually script exactly what a response
Right.
should be.
Yeah.
And verbatim, this is
Verbatim.
what you say if somebody
Yeah.
asks you about this. The matter has been settled amicably, and that's it. That's all they can say.
And nothing else to say.
You can actually script that, so you can get around that.
Yeah.
Next question. My company is set up as a partnership. I like to buy out my partner's share. What's the best way to do that to avoid legal problems?
The best way to do that is to set up the correct entity. You never want just a general partnership, ever.
Goes back to
Ever.
that.
Ever.
Personal liability.
Well, yeah, you have personal
Liability.
liability. It's joint and several, and so if you're not at fault but your partner is, and it's a $10 million claim, well, you're on the hook for that. And so set up the correct entity. Again, if you're a small business, an LLC is a wonderful entity to use. If you're a bigger business, you think you're going to grow, you want shareholders, then you might do a corporation or something else like that.
Yeah.
And it's really not that difficult. A small business owner can set up an LLC on their own. I would advise, again, because the operating agreement is so critical, that you consult with an attorney for that part of it. But just the nuts and bolts of registering with the Secretary of State is really quite easy. On their website, you can go through that process. There's a few forms, it's a few $100s to get registered.
Yeah.
So it's really not that difficult. But the key there, again, is the operating agreement, how to govern that relationship.
Yeah, it is.
For your documents like contracts, is there a certain time frame in which I should keep those documents just in case there's some kind of issue later?
Yeah, it depends on the type of contract, because
Okay.
every claim or class of claims have a separate statute of limitations. And what a statute of limitations is, of course, is the time with which one has to sue somebody over that claim. So if it's a contractual claim, if it's a written contract, it's 6 years. So you probably want to keep your documents at least 6 years. If it's an oral contract, it's a shorter period. If it's a tort, it's even shorter. So this is where it comes with the document retention policy. You consult with a lawyer. It's like, what kind of business? The lawyer's going to ask you, what kind of business are you in? What kind of documents do you deal with? Okay, this is how long you should keep these. This is how long you should keep these. This is how long you should keep these. And ideally, you should have a calendaring system so you can start to churn out and get rid of these documents as you don't need them, rather than keeping them for 15 years. Because there's no reason to keep them for 15 years, and chances are they might even hurt you for keeping stuff so long. So that's the answer to that.
And just as a caveat, there's certain claims might get tolled, which means their statute of limitations is extended until somebody is actually aware of a claim existing.
Right.
So it goes to what the person knows, not when the contractor started. So that's what's known as the tolling of that claim, which can be very detrimental, obviously, to the business. And so, again, having a lawyer help you understand what those might be, I think is also helpful.
And it's also helpful for a document destruction policy.
Yeah.
Right, because regardless of the tolling, if your policy is reasonable, the fact that you don't have these documents isn't going to hurt you just because someone didn't discover it.
Right.
You know.
Here's another question. I have a family-owned business that I plan to pass on to my children. What type of succession plan could I set up to avoid litigation in case my children disagree with each other?
Yeah, I think the first step is to actually have a succession plan. All too often the succession plan is at the graveside as family members just start to fight over who's going to be in control. So my advice to clients is, if it is a family-run business, you should have these conversations with your family
long before
they die.
principal dies,
Long before the principal dies. So everyone understands what each family member's role is, what their expected role will be going forward. If it's changed, you need to have conversations with those family members.
And you document it.
And again, it all ties into two things. One, communication with family members, so everyone's transparent, open, and honest. Dad says, Billy, I love you, but you're an idiot. You're not going to run the company. You're going to be head of the logistics. You're really good at logistics, but you are not good at finance. And Mary, you're really good at finance. That's what you're going to do. And then you document it in the documents governing the company. Trust me, it will save a lot of trouble later. Rather than having nothing because Dad ran everything or Mom ran everything, didn't cede any power or control to anybody else, and did not leave their wishes in writing as to what would happen. That's called a bonanza of litigation.
Oh, yeah.
And it's family, and they really hate each other.
And that could...
That's the worst.
That could, at the end, kill the company.
Yeah, exactly. We've seen it. I mean, closely held companies destroyed because the family members hate each other. And there is no hate like family hate, right?
That's right.
Right.
None. So we got our final question, which is, when is a professional mediator a good choice, and why would I want to go that route?
You know, we talked about a number of times having an objective view. That's why you have an attorney to try to help you look at the law objectively, look at the facts objectively. That's really the role of a mediator. Dispassionately can look at the whole case and then make a decision as to, really, he's there to try to help the two parties communicate so that they can reach an amicable or some sort of separation. That's what his job is, to look at it objectively. So when the parties are unable to do that themselves, they might turn to a mediator. It might be a way of preventing litigation, which is very expensive. A mediation,
right.
Though there are costs involved, will certainly be less expensive than litigation. So,
yeah. And there's a lot of factors that go into mediation. I mean, there are certain classes of cases here in Nevada that are subject to mandatory mediation. The biggest one that comes to mind is our employment claims. Our U.S. District Court here has a wonderful mandatory program where after an employment claim has been filed in the U.S. District Court, that there is an early neutral evaluation conference. And that means the parties, your client, is ordered to attend with their lawyer to meet with a court-appointed mediator, which is quite often a United States magistrate judge. Okay. And there's a lot of value to that because lawyers, of course, have their own view of the case, and the parties have their own view of the case. The value a good mediator brings is that they truly are kind of a faux judge, right? You're really getting a third view.
Right.
And that's often convincing to parties, especially if the stature of the mediator is high. I mean, people respect
not all mediators are created equally.
Right, right, exactly, right? You got to find a good mediator.
A good mediator is somebody who has specific experience in that area.
Right, and has the stature to command the respect not only of the attorneys but of the parties. And so you have to choose your mediator according to your case, but there is a value to it. There is a value, but that really has to be assessed on a case-by-case basis. It's valuable sometimes because it really just does kind of calm clients down, because they don't often really
And the
believe.
perception sometimes is, well, they're just going to split the baby. They're just going to pick a middle road. That's not always the case. They
No.
can look at a case objectively, and oftentimes they come up with solutions that neither of the attorneys have thought about.
It also gives a reality check. I mean, there's one mediator in particular in Nevada who's been here forever. He is very well respected. And when I need a client to have dad or grandpa take them to a corner and tell them what life is all about, this mediator can be very effective because they have stature and they have age and they've got wisdom, and people listen.
And they can say, this is what your claim is worth, and it's not $10 million.
I've been doing this for 50 years.
Right.
Yeah.
And that type of gravitas that they bring will
right.
help
Will
diffuse
help.
the situation.
It will.
Well, I thank you both. I've learned a lot, and I'm sure our audience did as well. So thank you, John. Thank you, Ray.
Thank you, Mario.
Thank you.
And on behalf of Nevada State Bank, I'd like to again thank John and Ray for presenting this valuable information. We hope you can apply some of these ideas to help protect your business. And thank you to everyone who participated, especially those who submitted questions via Twitter. If your question was not answered today, we'll send you an answer in the next few days. If you'd like to see the webinar again or invite others to see it, a recorded version will be available later today on nevadasmallbusiness.com. Also on nevadasmallbusiness.com, you can find lots of valuable resources for your business, including articles on business topics and links to previous webinars in the Insights series. If you have a family-owned business, please visit our webpage, nsbank.com/familybusiness for newsletters, webinars, and more. Thanks again for participating, and have a great day.
Thank you, Mark.